fast forward 10 years from that 1997.
Yes.
You then write a judgment. It's engine
petroleum.
versus the CCMA.
Yes.
Now, there had been a judgment of the Supreme Court of Appeal by your now brother, Edwin Cameron.
Yes.
In which he applied what's called the reasonable employer test.
Yes.
To determine whether or not the dismissal of an employee was reasonable or not.
Yes.
Right?
Yes.
Now, he applied that test.
Yes.
You, 10 years into your stint as a judge, I think by now you are in the Labour Appeal Court.
Yes. I was JP.
You write a judgment. This was before the Labour Appeal Court became the apex court in labour matters. People could still appeal to the Supreme Court of Appeal. Yet you write this judgment in engine. You disagree with the Supreme Court of Appeal and say, no, the reasonable employer test is not part of our law. Take us through what your thinking was as you are reading the judgment of the Supreme Court of Appeal and penning this judgment, disagreeing with the higher court. But of course, recognizing that because the higher court has said this, you are bound by it, but you disagree with it. Just take us through what you think.
Well, it was quite an experience. Well, let me start off by saying what had happened was that a few years earlier, I had been part of a judgment which was written by Judge Nicholson, who was a judge of the Labour Appeal Court at the time, which had said the reasonable employer test was not part of our law. I can't remember whether I had written a concurring judgment or I was just, I concurred in his judgment. And before that, there had been judgments in the Labour Appeal Court which had followed the reasonable employer test. So after the judgment that Judge Nicholson had written, we had basically not followed the reasonable employer test. So I then gave a judgment in a matter, well, in the Zondo matter, which then was taken on appeal to the Supreme Court of Appeal. And at the LAC, I had not applied the reasonable employer test. I had not discussed much. I had not discussed it, actually, as far as I recall, because we thought it's settled now. It was settled. So then the Supreme Court of Appeal was seized with the matter, and then the judgment came out. And when I read the judgment, I felt that, the reasonable employer test, now that the Supreme Court of Appeal had said was the test, was really going to cause a lot of injustice in the workplace against workers and so on. I felt it was too biased in favor of employers, And I thought that I felt strongly about it. I felt that while I've got to respect the decision of a higher court, I must put my views to say I believe it's wrong. And so that maybe one day either the Supreme Court of Appeal or maybe the Constitutional Court that explains that this reasonable employer test is wrong and the SCA is wrong. Maybe the SCA one day will reverse its own decision, or maybe the Constitutional Court might deal with it. So I wrote that judgment, and as you know, I traced that reasonable employer test back to a judgment by Lord Denning in English law, House of Lords, and it was based on a particular statutory provision which had no equivalent in our own statutes. And I looked at various things and so on. I looked at international labor law. I found that there was no basis for it. So I expressed that view, and
Of course, the Constitutional Court then, a couple of months later, in Zondo,
Yes,
endorsed your approach.
Yes.
How did that make you feel?
Well, put it this way, not so much for myself. I was just happy for the labor law jurisprudence and for workers, because I thought that the reasonable employer test was very much biased in favor of workers, and what we needed was an approach that would be fair to both sides and take into account their own situations, and therefore, from that point of view, I was happy for them. Yeah.
I have to ask you this question. You were appointed in the Constitutional Court in 2012, and subsequently as now Deputy Chief Justice in 2017. Tell us about a typical day in the life of a Constitutional Court judge.
Yeah. Well, there are maybe 3 types of days in a Constitutional Court, in the life of a Constitutional Court judge on any particular day. One day is when you may be going to court to hear a case. On such a day, obviously, ahead of that day, you would have been preparing. On that day, you come in the morning and then you get ready to go to court. You go to court, you come back when that's done, and you might do whatever chamber work there is to do. But basically, if there's a hearing, that's what takes your the best part of your day. Of course, when you come back after the hearing on such a day, you would look at whatever else you need to do. You might have judgments to write. You might have other judgments to complete. Excuse me. You might have other colleagues' judgments that you must read and comment on. There might be memos from colleagues and from clerks in regard to applications for leave to appeal or applications for direct access that you must look at and comment on, so that your view is known as to where you stand on certain issues. So that's the one day. The other one is when you are not going to court, but there is a conference. Normally we have a conference on Wednesdays. That's just a meeting of judges to deal with a number of issues that come up every week. We have such a meeting only once a week during term.
What are the typical issues that come up?
Well, basically, it's applications for leave to appeal that we dispose of without a hearing. So people apply for leave to appeal, apply for direct access, and there would have been 2 colleagues who would have looked at that application and circulated a memo to the rest of the colleagues to say, we have looked at this application, this is what happened, and these are our recommendations. Maybe the recommendation is dismiss the application or set it down for hearing or ask for give directions for written submissions, that kind of thing. So those are disposed of mostly at conference. And then there would be other issues that the Chief Justice might wish to raise or that colleagues might wish to raise relating to our work, but mainly it's applications. And that conference, takes a few hours, maybe 3 hours. I hear that some time before I came here, it used to take quite long. But apparently with the current Chief Justice, the time was reduced. And then if you are not going to be in court and you are not going to be having a conference, then you'll just be in chambers. In that case, you would be looking at research, looking at material that your law clerks might have prepared for in terms of research work, memos. You would be reading, you would be writing judgments, and you would sometimes need to have discussions with colleagues on certain matters which have been had, where you need to discuss. Sometimes you know that the one colleague is taking a particular view, you're taking another view, and sometimes colleagues at conference say, well, maybe the 2 of you should have some discussion to see where really your differences are. So you might have that kind of discussion and see where you really disagree, and maybe during that discussion you find some common ground. So that's what you would be doing.
I'm glad to hear that a day in the life of a Constitutional Court judge doesn't include discussing counsel.
No, not at all.
That's a relief. But can I ask you this, on this dismissal of applications for leave to appeal in conference, has there ever been occasions, because I've seen these and usually it's unanimous.
Yeah.
Have there ever been occasions where there is a split about whether they should be granted or not?
Well, where there is a split, what we would do is say, well, the matter should be set down for hearing, because it means that there may be different views. So those ones you are unlikely, you won't see any split, because if there is a split, it's likely to be set down for hearing so that there can be a judgment. Sometimes what is done is it might be decided that there should be a short judgment without a hearing. So parties are just invited to deliver written submissions on certain points, because sometimes there are differences of opinion before there is a judgment. But once there is a judgment, you might find that people get persuaded, and then there is unanimity. But also, even if there is no unanimity, then there could be a dissenting judgment. But at least if there is a judgment, that's much better, because if there's no judgment, it's difficult to just send something and there's a split and parties want to know what the reasons are. Yes. Yes.
Now, let's talk about briefing patterns. What has been your observation sitting in the Constitutional Court of the race and gender representation of counsel appearing in the Constitutional Court over, say, the last 6 years? And I'm not talking about counsel who appear before you to note judgment.
Yeah, no.
Would you say that there has been an improvement in, say, the last 2 years when compared to when you first arrived here in 2012?
I must just be careful, because the last year from August I was not sitting. But yeah. Well, my sense is that either there isn't any improvement or the improvement is very limited. That's my sense. Certainly when I started here, there were very few black counsel that appeared. Maybe there is some improvement. I just haven't sat down to really make it. But there hasn't. I don't think that there's been much progress. One still finds that in very, very many matters there is no black counsel. But of course there are some matters where there is black counsel, or there are black counsel. But one tends to see, in terms of black counsel, one tends to see roughly more or less the same faces. It may be that with regard to white counsel it's the same thing. I'm not sure. Well, certainly one knows that there are certain counsel who frequent the Constitutional Court. That's for sure in terms of white, but also in terms of black. It's just that the numbers would be very different. There are some who do frequent it. Then there are others who might not be frequenting it, but they appear in the Constitutional Court with a certain degree of regularity.
Would you say it's the same in relation to gender? whether white or black women, what's the representation there?
My own sense, not having checked, my own sense is that there is probably, in terms of gender, the situation is worse than race. I'm thinking, but I'm doing so without having checked the statistics. But my sense is that with regard to gender, it might be worse, that there would be fewer women, whether white or black, who appear in the Constitutional Court. That would be my sense.
Assuming that's correct, CJ, to what would you attribute such paucity of women and black counsel appearing in the Constitutional Court, led or unled?
I think it's a serious problem. Well, let's talk about just black, but some of this might apply to gender as well. Before 1994, my own sense is that there wouldn't have been any lawyers who could talk of having any experience of constitutional law in practice in the country.
Black or white.
Men or women, It may be that a few who might have had some practice or might have been involved in some cases outside of South Africa might have had some experience. But in the country, you say really nobody could talk of practical experience. People could talk about, academic, knowledge, blah, blah, blah. But of course, we know that when we look at the first panel of Constitutional Court judges that came in, and we move from the point of departure that many lawyers, black, white, female, male, wouldn't have had that experience. They came onto the Constitutional Court, and we know that when they left, their time left, they left us with a very rich constitutional law jurisprudence, Now that's very important, because it just showed that you might not have had practical experience, but if you are given an opportunity, you can make a meaningful contribution. Now, one would have thought that that is something that should make a lot of people who have Constitutional Court cases, would make them give work to black lawyers, women lawyers, because it can be done. There is demonstrable experience. It can be done. It hasn't been happening the way it should, and I think that in part government is supposed to be leading, as far as I'm concerned, in giving black lawyers and women lawyers work in regard to not just constitutional cases, in regard to many other fields of law, but certainly if we talk about constitutional law, almost all constitutional law cases involve government.
Yes.
So you ask yourself the question, who is government giving cases their briefs to, if we have this kind of situation where very few black counsel, black lawyers appear in cases in the Constitutional Court? And it's difficult to understand why they don't give work to black lawyers, women lawyers, in large enough numbers to have made sure that this picture that I'm talking about has changed. They should have made sure. But I don't know whether it goes back to people not having confidence in black lawyers, in women lawyers.
Which would be odd, because as you say,
yes,
the first lot of
yes,
constitutional court
yes,
judges hadn't practiced
yes,
constitutional law.
yes,
They left a rich jurisprudence
exactly,
of constitutional law.
They did.
Would you then say, DCJ, that the government has a major role to play in addressing briefing patterns, especially in the constitutional court appearance and jurisprudence, if the vast majority, certainly as far as I'm aware,
yes,
when I read constitutional court
yes,
judgments,
yes,
I see government in one iteration or another. It's either municipality, or it's the national government, or it's the speaker, or it's the president.
Yes. No, definitely they should be giving a lot of constitutional court cases to black lawyers and women. I mean, after all, they know exactly the situation. They know where we are coming from with the exclusion of black lawyers and women from, getting good work, good cases to go and do, and being involved for legal advice in important matters, even commercial matters. But constitutional court is just one clear example where government can make a huge difference by making sure that that a lot of black counsel get this kind of work.
I'm going to ask you a broad question and give you a blank canvas to give an answer to this one. Is there anything about the state of the legal profession today that keeps you up at night?
Well, it's mainly the exclusion of black lawyers from certain branches of law, and I get concerned. Maybe it might not necessarily be keeping me awake in the night, but it's a matter of serious concern to me, because I ask myself the question: if 25 years into our democracy, we still have a number of branches of law in which, for all intents and purposes, black lawyers and women are excluded, when are we going to reach a point where we will say, now the situation has changed and it is what it ought to be? And what are the measures that we need to take to try and fast track that process? So that can, both in terms of government and in terms of the private sector, I just wish for a situation where companies in the private sector, when they have all kinds of cases, they can brief a lot of black lawyers, a lot of women lawyers, So that worries me, and it's something that all of us should every day try and do something about. We should talk about. We should try and put pressure on those who have power to give, to break those barriers. Put pressure on them to do that. I think your question related to the legal profession or just to the legal profession. I think that, of course, tied to that is the issue of transformation in the judiciary. So that's tied with the issue of the exclusions. I would like to us in the judiciary to reach a point as soon as possible where, when I open a law report, when it comes to certain branches of the law, I see black judges or women judges having written judgments. I mean, at the moment, I think you struggle, or the last time I looked, it was a struggle to find a black judge or maybe a woman judge also has written judgment in tax law, in patent law, some of the intellectual property, branches, and so on. So that needs to change. And of course, some of those things will be facilitated if we look at when students graduate from universities and start their articles. For example, if they go to law firms that have got various branches of law as part of their practice, it helps. Yeah. So that is something that keeps me quite concerned. Yeah.
At least there is at least one judge in the Pretoria High Court, Judge Mali, I think.
Yes.
Who has a tax law
experience. Yes.
And she sits as a judge in the Special Income Tax Court and appeals.
Yes. That's excellent.
She was my classmate in
adversity.
Oh,
that's very good. But we should have more of them.
Yes.
Yeah.
And of course, talking about reportable judgments,
yes,
you will probably know that it's a very fluid system.
Yes.
Some judges come and they mark their judgments reportable and they never get reported.
No, that's true. That's true or another. No, that's true.
Someone is yet, or the editors in
yes.
are yet to explain
Yes. No, that's true. That's very true. That's very true. Yes. That might be one of the reasons. Yes.
Now, I'm tempted to peg this next question to the next session.
Yes.
In fact, let me do just that. Let's conclude by just asking you for this session what it is that you do to relax and unwind.
Well, one, I like listening to music. And I like almost all types of music. I like Istatamia, the Ladysmith Black Mambazo type of music. Yes. Yeah, that's right. I like Maskandi, I like gospel. And I like country music. I like a little bit of some jazz, but
only a little bit.
Only a little bit. There was a time when I didn't like it at all, but over time I've come to appreciate some of it. Some of these musics that young people play, I enjoy them as well. So I'm very diverse when it comes to that. So I like doing that, and sometimes when I can, not very often, I would play table tennis. I like playing that as well. Yeah.
Play chess like you showed us.
No.
I know a lot of people from Durban who like playing chess. It seems to be a provincial sport there.
Well, I don't know. I've never played it, well, when I was growing up, I used to play soccer. I played a little bit of tennis, but at this stage, it's more table tennis when I get time. Yeah.
CJ, a very last question for this session. Is there anything you'd like to share with the followers of this website on any topic? You don't get a wider.
No, I think what I would like to say is that we have a very beautiful country. We have a rich history. We have certain challenges. We seek to establish a certain type of society. and there are certain challenges as we seek to build that society. All of us should play our role in trying to make sure that we have a better society that we build for ourselves and for those to come after us. And each one of us has a contribution to make. However small you might think your contribution will be, it is important. And if we are able to reach a point where when we depart from this world, we think we have made a contribution to creating a better society, that would be something that those who come after us would be happy about.
Thank you, Deputy Chief Justice. Will you vote in May?
Yes, I will vote in May.
Responsible citizen.
I will vote.